Okay, great. All right. Well, good afternoon, and thank you for tuning in. My name is Liana Alston. I'm a law student at Howard University School of Law here in DC, and a research assistant for Professor Latif Matima, who is a professor of law here at Howard, founder and director of the Institute for Intellectual Property, Social Justice, and a colleague and dear friend of our guest today. So today I have been afforded the privilege of speaking with Professor Daryl Lim. Professor Lim is both the H. Laddie Montague Jr. Chair in Law at Penn State's Dickinson School of Law, as well as a faculty co-hire at the Institute of Computational and Data Sciences at Penn State University. Professor Lim also serves as Associate Dean for Research and Innovation and founding director of the Intellectual Property and Innovative Initiative. Professor Lim has an undergraduate degree from the National University of Singapore, law degrees from the National University of Singapore and Stanford Law School, and a degree in economics and management from the London School of Economics. And his research focuses on IP law, antitrust law, artificial intelligence, data security and privacy, and the architecture of innovation. So with that, good afternoon, Professor Lim. Thanks for joining me.
Good afternoon, Liana. It is such a delight to be here. One of my proudest titles is Dear Friend of Professor Latif Matima. So I'm glad you got that in the introduction. He is someone I've got great respect for, and I had the pleasure, as you know, of interviewing him a little while ago and learning about his journey and some of his leadership insights. So it is nice to be able to return the courtesy and do this with you for him and the Institute for IP and Social Justice.
Yes, absolutely. This is a privilege. So let's start with you. So could you tell us a little bit about your story, your personal and academic and professional background? Really interested to hear that in your own words.
Thanks for the question. Well, I'd say the key takeaway is never think that you know what tomorrow will hold. And when I first started at law school in Singapore, as you had indicated, was looking at practice in Singapore, and I was not even thinking about studies here in the United States, much less establishing a career for myself here in the United States. But I think one conversation led to one opportunity, and an opportunity led to a lifetime of traveling. I think I'm still on that journey. What happened was I decided to do a master's in intellectual property. At that point in time, a new think tank that's focused on intellectual property. Singapore was moving rapidly from being the piracy capital of Asia, not the sword and guns and steel type piracy, of course,
Right.
but there was that his part of its history. It was software piracy into one of the strongest advocates of intellectual property protection anywhere, and it is still uh, an accolade that it continues to hold today. But it was anxious to sign the free trade agreement with the United States, and as part of that, an obligation to strengthen its intellectual property rights protection, which it did. And it didn't just want to do that with the industry, it also wanted to think about how it could engage academia to really roll out a system and an ecosystem of intellectual property appreciation and integrating that type of research, the type of rigor in policy making all throughout different areas. And so it was in that setting that I decided that this was an opportunity of a lifetime. And at that point in time, they were also thinking of implementing its Competition Act, what we call antitrust law here in the United States, really in conjunction with a more broad thinking about innovation policy. And they offered a scholarship. I took a chance, applied for it. They were kind enough. They gave it to me. And that switched the course of my life entirely because I was going to go into general litigation, very different type of life. And that first year, I think, looking at intellectual property issues and the stakeholders that I got to interact with both within Singapore, but because Singapore is such a small place, interconnected in trade and other areas with the world, very quickly, the intellectual property part of it also exposed me to the international dimension. Thinking after I finished and went into practice about whether or not I should think about academia more seriously. And so I decided to apply for a fellowship at the Max Planck Institute in Germany. It is just a relatively short period in my resume. You had not mentioned it, but I would not have expected you to. And in London at the Queen Mary IP Institute. But my time at those two places, relatively short as they might have been, I think helped to crystallize the importance of the subject area and the potential professionally to make a difference. And so it was in that context that I started my further postgraduate education in California, the same side of the continent that you first started.
Correct. Yes.
As I understand, and both of us now find ourselves on the East Coast. So it's funny how life works.
Yes.
The Fordham Law School was actually the primary reason why I had moved east, because they offered me a 2-year fellowship there. I had the opportunity to teach copyright law, intellectual property survey, and patent law, European IP law, and really to integrate into US IP academia and academia more broadly. I very much enjoyed my time at Fordham and in New York, really the hub in many ways of the world's commons. And while I was there, I applied for a position and got an offer from the John Marshall Law School, which is one of the oldest IP institutions in the country. Its IP program was founded in 1940, I think long before most other places internationally, not just in the United States. And so it has had a long, proud tradition in intellectual property law, but also, as I'm sure we'll get to, access, equity, and inclusion. And so my introduction to IP as a career at the John Marshall Law School was very much tied to, I think, a similar vision and a mission as at Harvard and the Institute for IP and Social Justice. We didn't have quite as crystallized and clear and snazzy title in the program as the IIPSJ. But I think the vision and the mission were also closely aligned in that sense. And as a junior faculty member, one day I was unexpectedly asked to step into the role of director of that program. And I said yes, it was a tremendous honor and opportunity. I led the program from 2015 to 2021. And then in 2022, well, that's when I started to hand things over to my successor, Gary Freelander, who's doing a great job. So, in fact, I probably led the program for a good half of that year before Gary took over. And he has been doing that since I transitioned, as you noted, to Penn State Dickinson Law, where I wear now multiple caps, and happy to talk more about those. But I think I've said quite a bit for now, so I'll pause and wait for your next question.
Yeah, sure. Well, first of all, you said that you talked about the Chicago program and John Marshall, and we overlapped there as well. So I've just been following you around the nation, it seems. But yeah, I was a paralegal there for a very long time before law
Yes,
school.
I love the Windy City at
Yeah,
Steptoe.
at Steptoe, yep. And
Yeah.
I was actually a member of the IPLAC association for a little while too, and I saw that you were part of that, the
Oh, that's
Intellectual
cool.
Property
Yes.
Law Association. Yep, and it does ring a bell how old
You know, I don't know if you realize that, but I learned it long after I become a member of IPLAC that it really was the oldest IP association in the country.
yeah,
And so Chicago, in many ways, was a leader in IP protection. And IPLAC, as you know, is a really dynamic organization. And when the US IP Alliance was looking for a state to start its state alliance, Illinois was a natural choice, I think, in large part because of the good work that IPLAC had been doing over the years.
interesting. Oh, that makes sense. Yeah. Well, let's see. I really want to get to I have some specific questions about your research, which is a bit over my head, but I really want to get to that. But before we do, still on the with your background, I'm also interested in um, let's see. Well, I'm from Southern California, and I have family in tech. My dad is a PhD in electrical engineering, so I was always sort of, around. He was always in different startups growing up, um, and now he's at Qualcomm. Um,
So
but uh,
text in your genes.
it is. I've used a little of my. I tried to avoid it. I like people. I like talking, and so law seemed like a good fit. But you know, I found Professor Matima, and it was over. It was a wrap. But
He have you at hello?
what'd you say?
Did he have you at hello?
Yeah, I mean,
Well, that's a reference from
from the movie. Yeah,
Jerry
absolutely.
Maguire.
Yeah,
Yes.
he did. Absolutely. That's what I mean. You see, I'm here. So, wonderful, wonderful mentor and teacher. Um, and his class it really did feel like a coming home, like hearing all these things again. And it's been great. Um, but I'm interested in, I know that as a Black woman in these spaces, and even more so, like my father and the previous generations that sort of started NSB and for us in these spaces, it's not much of a leap to IP social justice, but it's incredible to it's not a leap once we start doing it because it's just seeing ourselves holistically in the space and our communities holistically in the space, obviously. But even coming before starting an intro to IP with Professor Matima, I didn't realize that it would have a social justice bent. I found that out in class. Um, Similarly with you, I'm wondering, I know that Americans in general, we can sometimes have a bit of like a blind spot, a bit of a blind spot about the rest of the world. We focus a lot on America and our perspective here. So I wonder if you could speak to, you know, bringing everything you've brought from your home country, from the other countries you've been to, and seeing IP all along through that lens organically. I don't know how to even formulate a specific question. Like, what do you notice? What do you think you bring to these spaces that maybe you hear yourself saying over and over again that hasn't been said until you say it? Um, what does, I guess, IP social justice mean to you, someone with your background?
Well, it means a lot to me. I think when you look at the intersection between IP and social justice, it really opens a whole new paradigm. As you know, being a student and soon to be expert of intellectual property law, there's very much a focus, especially in this country, on the economics of intellectual property rights. If you look at the European conception of intellectual property law, the theory is very much based on the human and the individual. But again, it's the dignity of the individual rather than society and social justice. I think we are at the cusp of a new era where we are forced to reckon with the inadequacies inadequacies of both of these worldviews, if you like, and to recognize that there's a whole segment of our population of society that's being excluded from the patent system, from the creative arts, from participating for the benefit of the societies they're in, for the nations that they are in. And in so doing, uplift not just themselves, but everybody else in the process. And IP provides a tremendous opportunity to social equity in a way that very few other areas in industry can do. I think it really is on the shoulders of both leaders and pioneers like Professor Matima, uh, acolytes like myself, still getting into understanding the nuances of how IP and social justice intersect with each other. But perhaps most importantly, Liana, you and the next generation and the generations after you to really take this seed that Professor Matima and um, others who have been doing this work for so many years ahead of myself and really growing it, helping it flourish. And this is not just something that can change IP. This is something that can change the world. And so to be part of it living at this point in history is a wonderful privilege, but it's also that opportunity that is awe-inspiring, almost like 1776 all over again. We are at the cusp of founding a new world. Now, what we do with it, that's up to us.
Wonderful, wonderful answer. Let's see. So in particular, you've proposed some ideas right at the intersection of IP and antitrust law, which I found interesting. I haven't taken antitrust law. I worked for an antitrust lawyer briefly.
Take it, you won't be ever out of a job.
Let's hope so. I don't think so. But let's see. You proposed, I guess, antitrust law as a possible route to IP social justice. And definitely jump in and correct me when I'm misstating anything and you discussed in one of your papers how antitrust law can be used to limit access to and use of databases without altering the current intellectual property regimes. Does that ring a bell? And can I think that was in someone else's paper describing your work. Could you maybe elaborate a little bit on that intersection?
Well, let me perhaps answer your question more broadly and talk about how I see antitrust law and intellectual property law intersecting in a way that would be useful in promoting some of the results that we were just discussing a few minutes ago. So antitrust law is really a regime that encourages competition and innovation for the good of consumers. It helps to bring prices down and helps to make products easily accessible to those who want them and to encourage investment and innovation in the next generation of products. So this is very similar in many ways to intellectual property rights. How intellectual property rights owners use those rights can sometimes be in conflict with those goals. Now, when that happens, antitrust law comes in as an external check, and intellectual property rights can serve as an internal check. So they work in harmony with each other if executed well. And that means that whether you are at the top of the social hierarchy or at the bottom, you can access what you need to. Execution is where the devil in the details come out. And part of the problem is that the different stakeholders advocating their side of the story don't talk to each other. And as is often the case in the United States, it's about who shouts loudest, or who is the most effective lobby group that generates and shapes the law. I think we're getting a bit better about talking not past each other, but with each other. But I think we are still in work in progress. I'll give you one example. There's a lot of conversation right now, today, about non-competes. And non-competes are a way that companies can use to stop their employees, soon to be former employees, from working for their competitors. Now, if you're working at Jimmy John's, that is crushing, that is restrictive, and you will not be able to easily find another job in that area. And if you're working at Jimmy John's, it's not likely that you can go across the country and find a professional job there. So you are geographically limited. In those circumstances, non-compete should be viewed with skepticism. But at the same time, if you are in Silicon Valley or if you're in Southern California working for Qualcomm, and you have agreed to work for one of the leading industries and giants in the world in semiconductors and microprocessing, and then somebody from another country says, please work for us. Well, in California, non-competes are illegal. And so by the time that Qualcomm says, oh dear, our trade secrets have gone together with the head of our ex-employee into this rival, but bad enough that that rival is in the United States, worse if that rival is overseas and it's one of the adversaries of the United States. To bring a trade secret suit is like trying to shut the stable after the horse has bolted. Whereas if you have a trade, the non-compete, it is a clear contractual issue, and it's much easier before the genie has escaped from the bottle to tell the judge, please enforce this. So you can see that there is a nuance that needs to be taken into consideration when enforcing non-competes, or when we should be skeptical of non-competes. And there's that social element there, as I've just described, as well as an innovation element. So these are issues which are complicated, but which need to be carefully dealt with in order to make sure that we don't either further marginalize particular groups or prejudice ourselves when it comes to intellectual property rights and trade policy.
Right. Well, so would you recommend that law students studying IP should take an antitrust course? Do you think?
Oh, absolutely. Absolutely. It is sort of like saying we learn how to tie our right shoelace, but not our left shoelace. I mean, you need both to work in tandem. And it used to be that intellectual property rights lawyers saw antitrust lawyers as the work of the devil and vice versa. Now, I think with the emergence of important cases over the years like Qualcomm, like Microsoft, and now with the digital platforms, I think there's a greater appreciation of the importance of tech as well as the dangers that they pose. And we are in a privileged position, Liana, you and I, to be able to observe these things from a legal perspective, from a plenary perspective, from a perspective that allows us to shape how things go forward to the extent that we can speak to the rules that govern these. But so many other people depend on those rules in their lives, and they have no say in it, except in the most attenuated way. So absolutely, as lawyers, as law students, the difference that you can make is tremendous. If you know how to, and to know how to, you need to first of all acquire that knowledge.
Awesome. Thank you. And then artificial intelligence is another hot topic. Let's see, I'm interested in what it looks like to obtaining IP justice in the IP context. Let me try again. Obtaining artificial AI justice, artificial intelligence justice in the IP context, and the two solutions that you proposed in your AI equity and the IP gap article. And I believe it said two areas where IP law impedes equitable AI-related outcomes are one, the civil rights concerns that stem from trade secrets blocking access and deflecting accountability in biased algorithms or data. And two, the patent and copyright doctrine biases that perpetuate historical inequity in AI augmented processes. I latched onto that because I saw civil rights, but I was wondering if you'd like to maybe give another nice, like high-level explanation of those two proposed solutions.
Sure, I'll start with civil rights, which you latched on to. I think if you look at the speeches of Dr. Martin Luther King Jr., and when he talks about civil rights, he's really talking about two things. He's talking about freedom, and he's talking about the right to work and sort of access, freedom and access. In fact, his march in DC was not just a march for freedom, that's what people latch on to, but it was a jobs focused march. They wanted the right to work. And I think when you think about intellectual property rights as well, it's about the right to participate in the intellectual property system as a equal, as an equitable, and there's a difference between the two, which I mentioned in the article, a member of society. And we are sometimes blinded by the structural inequalities in the intellectual property law system. We talk about it in many other contexts, but we often think of intellectual property rights as being technocratic and sort of like peering under the hood of a car. You don't normally do that. I don't think many people do, even though they own a car. They leave it to the mechanics to do that. But because intellectual property rights, as you know, touches every music, whether it's through brands, whether it's through the technology that we use, that it's important that we understand those structural biases that can be baked into the system and which can be exacerbated by AI. Because AI, if you like, is like a magnifying glass. It does not necessarily make you prettier or uglier, but it certainly amplifies whatever is already there. And so the two solutions that I mentioned really focus on data. More data, more good data, less bad data, but better data is ultimately, I think, the crux of it. And what I call equity audits, which are done in so many other areas to make sure that the systems run, that accounts are done properly, but which are as important, if not more important, when we deal with something like AI, which on a daily basis we see becoming more prevalent, which, if unchecked, can have important and more difficult to unravel consequences. You might have heard of this analogy of AI being like a black box. And the opacity of AI is only going to get more and more as it's able to function more and more autonomously. And so when you have ChatGPT generating essays and law professors being worried about plagiarism and other issues, and now there are counter software to check if your essay was indeed generated by ChatGPT. It's an arms race. And what I'm suggesting with equity audits is really a countermeasure to recognizing the dangers that biased data can generate. And those equity audits really should go further than just the data, but more broadly to the theme of that article that you referenced, to look at structural deficiencies in the law, which may not have been a problem before, but which now that we know better should be remedied. And it's a continual process. We expect that of the operating systems on our phone. We get prompts every now and then. It seems to be working fine, but then they discovered a bug and we fixed the bug. Same with AI and same with IP.
Wonderful. Thank you. And then along the lines of ChatGPT and the actual sort of user-friendly programs that are out there now and that will continue to come out and get smarter and smarter. I know I was immediately thinking back to my paralegal days and the sort of burgeoning of litigation technology. When I started, we were sometime between Adobe and actual Bates labeling, actually printing labels and putting them on the documents. And then came along concordance, and then came relativity, and then came analytics. And I remember let me pull back and get more anonymous, certain staff in certain law offices being a little concerned, just like, super professional, but very concerned that maybe the litigation technology was going to take away paralegal jobs. So I'm wondering, as a law student coming in at this time and graduating into this, I wonder, like, what will continue to make us useful as people gain access to software that, for instance, can draft their brief for them, which my social justice mind is all for. I don't think we need, if we have less lawyers in the world, that's not the worst thing. If people can do more for themselves more efficiently, that's a wonderful thing. But what do you think will be some of the traits that will continue to be necessary for law students coming in, for lawyers 20, 30 years from now? What can't GTP and other AI programs sort of replicate?
Yeah, that's a great question, Liana, and an important one for securing your future as a productive and well rewarded member of the legal profession. I think, let me answer your question this way. I was having a conversation with a professor at Cornell, and I asked him something similar. And through the conversation, I think we both agreed that ChatGPT is not going away. In fact, it's just a symptom of really a sweeping change. And just like the horse and buggy was replaced by the automobile, just like gas is increasingly replaced by electric, so it will be that those who evolve, those who stay ahead of the system will continue to thrive. And that means that we need to understand what the levers of change are and where we can continue to be useful. I don't think that AI's point of singularity will come where we are replaced by machines. I think if you read the literature, there's an optimism that human beings will only become more important in that which makes them human. And that means empathy. And that means decision making. And being able to think creatively. None of these things are evident in what machines can do today, and I suspect not for a long time to come, if at all. So if you have a case, these are things also that make a good lawyer, even right now. Are you able to empathize with your client? Are you able to give clear, cogent, concise advice to your client, right? Are you able to think out of the box and provide solutions that your client may not think of or the law may not have yet contemplated? These are things which you will always be able to command a premium for, and which you can't program into the bits and bytes of a machine. Remember that AI is trained with old data. They can combine different bits to produce fancy pictures, if you like, but there's a certain finitude to them. And in fact, even now, if you look at how they put together pictures, they don't get the thumbs quite right. They don't get the lips sometimes or eyes quite right. And I think if you ask a 10-year-old to draw a picture of a human being, they would get the fingers right. They would get the eyes and lips right. And so there's a certain level of touch that is real and which you cannot remove from the human individual and transplant it into a machine. So those three, I would say, are going to be the core parts of it: the empathy, the decision making, and the creativity.
Wonderful. Thank you so much. I'm realizing my last question was a bit, you may not know how to answer it. It just speaks to how important your work is. But I noticed you were, by some metric, top 0.3% on SSRN for downloaded papers or reviewed peer-reviewed papers. People are coming to your work a lot. And I guess I was wondering, like, how do you come up with your topics? How do you decide what you're going to write on? Does a light bulb go off while you are teaching, or usually in conversations with Professor Matima or other colleagues at these other wonderful institutions you've been at? How does inspiration strike for you for the articles that you write?
Well, Liana, I think it's a bit of everything. We tend to think of ourselves as we're getting information from here and then here it goes out. But I think the human brain, to the earlier question that you asked, works in wonderful and mysterious ways. And the best thing I think I found useful in coming up with new topics to write about is to talk to people, to read, and to reflect. And when you can do the three, and the three are becoming increasingly difficult given all the other demands on my time, you actually can see in your mind's eye both issues as well as the passion that drives you to work to solve these. One thing you might have heard about the scholarly life is it can be quite lonely sometimes. And what keeps you working at night, what keeps you working through the weekend, is that passion. I think it's true also for practice. It's true for really anything that you've set your mind on doing. And I think there's got to be a bit of a social enterprise. There's got to be a bit of an individual point of endeavor and reflection. And then a realistic assessment of where your strengths are. So I wouldn't, for example, be doing regressions and complicated figures, but I can say something useful qualitatively and quantitatively about simple aspects of cases and so on, and I have. And see what sort of problems are relevant to the world. Academics need not bear the label of being these monks that live in a monastery or live on top of an ivory tower. What they propose can and should be deeply relevant to the problems that the world faces today, whether it's social justice, climate change, whether it's just getting us from point A to point B more efficiently, both in terms of the technology, but also the laws and rules that govern the technology. And that means that we need to certainly talk to more than people at the law schools or even in the fields that we are in. But as increasingly is the case, interdisciplinary research is important. But also thinking about when the rubber hits the road, talking to government officials, talking to industry, talking to lawyers, even talking to the next generation like yourself. So I'm learning as much from preparing for this interview, from learning more about you, as I have had the privilege of sharing with you in the last 40 minutes or so. And long may it continue.
Absolutely. I don't think that that's true. I don't think you learned as much as I did today, but um, I really appreciated this. This was wonderful. I learned so much in preparing and in listening to you and the way you asked questions. I knew it would be wonderful because I had the privilege of seeing you moderate a session at the 20th anniversary of Professor Matima and Professor Esther Lim Finnegan and Tom Irving's CLE, Social Justice CLE. And you did a wonderful job moderating a panel of in-house counsel. So I knew I knew no matter what I did, this would be a wonderful experience. So thank you
Well, you
so
did a
much.
fantastic job. And if you were learning, well, you are a quick learner.
I was. And I recorded this, so I can go back and I can make, okay, creativity. Okay. Uh, empathy, antitrust law. I've got all the tips and I will share with my classmates. Um, so thank you so much, Professor Lim. And I hope you make it to Howard soon.
I hope
To
so too.
campus.
It'll be great to meet you and Professor Matima in person before too long.
Yeah, absolutely. Okay. All right. Well, I will